Welcome to INN's Student. INN Student is a platform for law students to come here and deliver a lecture on the topic of their choice. Today we have with us law student Arpita Balle. She is going to speak on philosophy of Indian Constitution. She is from KES Shri Jayanatilal H Patel College of Law. So without wasting further time, I would request Arpita to commence with her lecture. Thank you.
Warm and heartfelt greeting to everyone. I am Arpita Balle and my topic for today is philosophy of Indian Constitution. Now imagine a country as diverse as a whole continent where millions of people speak ample of different languages, follow different faith and dream different dreams. What helps bring such a vast country and vibrant democracy united? What helps bring such a diverse population under one system to ensure fairness, justice, equality and unity? The answer lies in one single text, the Constitution of India. The Constitution is more than just a text. It is the soul of the democracy of the world and it is the blueprint of the future of our nation. The philosophy of Constitution isn't just about the law, but it is also about the principle which shapes India as a nation. It sets moral and political character of the state. Further into the lecture, we will dive into values which shape India as a nation. We will also see some significant events which led to the formation of the Constitution, and we will also see some landmark cases which contributed to the formation of the Constitution. Now, it is very difficult to put a single label on the Constitution because it is liberal, it is democratic, open and secular to communal values, and extremely sensitive to minority needs. The Constitution is committed to freedom, equality, social justice and unity. Now we will study the features of the Constitution which will help us understand the basic structure of the Constitution and as to how our Constitution works. The Constitution of India is a written constitution and it is the longest written constitution in the world. It is the lengthiest and the most detailed constitutional document of the world. It contains a preamble, 395 articles in 22 parts, 12 schedules and 5 appendices. The Constitution expresses the vision of India as a democratic nation. It also identifies the fundamental rights and duties of each citizen of our nation. And while doing so, it also reflects to our constitutional value. Now, moving on, it is very difficult to bring changes into our day-to-day life. As regards to the Constitution, generally written Constitution are unamendable. They are rigid and it is not easy to bring change into them. But our Constitution lays down special provisions for constitutional amendments. In unwritten Constitution like British Constitution, the amendments are made through ordinary law-making procedure. In rigid Constitution like the USA's Constitution, it is very difficult to carry out amendments. However, the Indian Constitution is neither too rigid nor it is too flexible. There are ways of amending the Constitution. The amendments can be made through simple majority in the Parliament, special majority in the Parliament, or sometimes even by special majority in the Parliament with the approval of the state. Moving on, the Part 3 of a Constitution grants fundamental rights and duties to its citizen. Fundamental rights are one of the most important features of a Constitution. The Constitution contains the basic principle that every individual is entitled to enjoy rights as a human. However, when these rights are violated, the humans also have a right to approach to the court to get their rights reinforced. Now, fundamental duties are added into the 86 amendments of the Constitution, and the rights guarantees the freedom of the people, whereas duties made sure that every citizen is expected to perform. There is a total number of 11 fundamental duties altogether. Now moving on, the Constitution of India is derived from various sources. Its provisions are mainly from the Government of India Act 1935. The structural part of our Constitution is adapted from a large extent adopted from the Government of India Act 1935, and the philosophical part is borrowed from USA's, the fundamental rights, the duties, the directive principle of state policy, all that is borrowed from the Constitution of USA. Whereas the political part of the Constitution is largely been drawn from the British Constitution. Moving on, in federal countries, the judicial system, in federal countries like USA, The judicial system are not integrated, whereas in India the judicial systems are integrated. At the top level, that is the apex level, we have the Supreme Court. At the lower state level, we have the high courts, and at the subordinate level, we have the district courts, district and lower courts. This unified judicial system is aimed at promoting ensuring that justice is providable to all uniformly. Now, also in federal countries, the citizens enjoy dual citizenship, whereas in India, a citizen of India is only citizen of India. They have the provision of single citizenship. For example, if a person belongs to a state of Maharashtra, he is not from the state of Maharashtra, or nor is he from the state of Rajasthan. He is a citizen of India. He is a part of India. This provision is adapted to make sure that all the regionalism tendencies are eradicated from the constitution. Now, the parliamentary system of the government. The Constitution of India has opted for British parliamentary system rather than American presidential system. The parliamentary system is based on the principle of cooperation, coordination between the legislative and the executive organs, while the presidential system is based on the doctrine of separation of powers. Moving on, to understand the source of a constitution, what things it took for the constitution to be what it is today, we have to understand the history of the constitution. Now, the evolution of the constitution can be studied in two parts: the company's rule and the crown's rule. The company here refers to the East India Company. Now, in 1600, the Queen of England issued a charter which granted exclusive trade rights to some merchants of England. Now, these merchants formed a company, the East India Company, and this company initially solely focused on the commercial part, and their political ambitions were not. They did not have any political ambitions. However, this situation changed over time. In 1612, Sir Thomas Best, he defeated Portuguese in the Battle of Swally and acquired the water controls over Surat. And after this, in 1613, Sir Thomas Alderworth, he approached the Mughal Emperor Jahangir and obtained permission to carry out trade in Surat. And now this led to the establishment of the headquarters of East India Company into Surat. Now, in 1639, the East India Company took Madras on lease, and they started carrying out trade activities over there as well. In 1612, King Charles II, he got married to Princess Catherine of Portugal, and he received Mumbai in dowry. And after that, he rented Bombay to the East India Company for £10 a year, and this event led to the shift of headquarters of East India Company from Surat to Bombay. Now, in 1717, Mughal Emperor Farooq Siyar issued a Farman. And the Farman is also called as a Magna Carta of the British imperialism in India, because this Farman granted exclusive trade rights to the East India Company in Bihar, Bengal and Orissa. Now, after the Battle of Buxar, the military force of Britishers grew stronger, and in 1765, Sir Robert Clive introduced the system of dual government, where the Nizamat rights, that is the law and the revenue and the taxes rights, stayed within the East India Company, and the Nizamat right, that is the law, police force and order, that went into the hands of Nawabs. This arrangement allowed the companies to exercise their authority without actually taking any administrative responsibility. As now the power in the company became concentrated, and there were insufficiencies and financial decline in the working of the company. The situation was so bad that the British Parliament had to intervene, and they had to pass on an act. That act is called as Regulating Act of 1773. Now, this act marked a turning point, shift in legislative and the transfer of political authority into the hands of British Crown. After the Regulating Act of 1773, the Governor of Bengal was redesignated as the Governor General of Bengal, and an executive council was formed of 4 members, and they were supposed to carry out the exercise administrative powers in India. even though there was no legislative body form. And after this, multiple acts such as Charter of 1813, which ended the monopoly of East India Company, the Charter of 1853, which separated the legislative and the executive functions. Now Revolt of 1857 happened, and Revolt of 1857 proved to be an event which marked the transition of the company's rule to the British governance. Now, after the revolt of 1857, Government of India Act was enacted, and through this act, the company's rule was replaced by the rule of Crown. Now, the administrative process was to be carried out by a council of 15 members, by a council of India, and he was to be assisted with 15 members, and they were vested with complete authority over the Indian administration. Now, after this, multiple acts like Indian Council Act of 1861, Indian Councils Acts of 1892, the Government of India Act of 1919, and the most important one, the Government of India Act 1935 was established. Now, due to exaggerating need for the independence, there was a rise in nationalist movement. Now, there were movements such as Gandhiji's civil disobedience movement, which forced the Britishers to consider constitutional reforms. Despite these many efforts to bring into constitutional reforms, the Government of India Act of 1935 was rejected by the Indian National Congress because it did not grant full independence to the country. Now, Indian Independence Act of 1947 was brought. After World War II, Britain's economic and political power completely weakened after the war. There was widespread of unrested force, and the Britishers were forced that they have to finally grant independence to our nation. Now, the Indian Independence Act of 1947 divided India into two parts, the India and the Pakistan. This act was through this act, responsible government at both central and provincial level was established, and this act marked the beginning of self-rule and the end of British rule. And this act also laid the foundation for the Indian Constitution. Now, during all of this, the India was under the British control, and upon the independence, there was a need that a constitution had to be made, and to do that, all of the Indian territory had to be in a union, which meant that all the princely states were required to be brought under one union. And this task was done by Sardar Vallabhbhai Patel and VP Menon. They did this task, and until then, India was still a legal domain under British control, and the Britishers were responsible for the external security. Thus, the Constitution of India replaced the Indian Independence Act of 1947 and the Government of India Act 1935. So now we have a fair idea as to what events it led to the formation of the Constitution. We will further move on to we will understand the contents of the Constitution through the preamble. Now, whenever we go to a bookstore or we are studying, we open a book, we read the preface of the book. So, what is the preface of the book? The preface of the book is basically the essence of the book. It summarizes the essence of the book and it is introduced to us. Similarly, the preamble is also the essence of the Constitution, and it summarizes the core principle and vision of a constitution. It is the reflection of India's constitutional philosophy. The first line of the preamble, "We, the people of India." It is the most powerful line of the preamble, as it establishes the authority of the source of the constitution within the people of India. It rejects any form of monarchy or any form of external influence and affirms that the power lies within the Indian citizens. The preamble declares India as a sovereign, socialist, secular, democratic republic. What does the preamble mean by it? Sovereign basically means that our nation is completely independent and is not subjected to any external power. It is free to carry out its internal and external affairs completely on its own without any third party intervenence. It has power to make its own laws and rules and take independent decisions regarding the national and international affairs. Socialist, meaning that the wealth of the India should be equally divided within the people, as it reduces inequalities. It holds faith in mixed economy where both private and public sector exist side by side. Secular, meaning that all religions are treated with equal respect, protection and safety from the state. It means that the state does not favor any particular religion. Since India is a land of diversity, and home to multiple faiths and religion, the state does not favor with any particular religion and treats every religion equally. Democratic. Democratic implies that India is based on the principle of democracy, where the government is elected by the people, for the people and of the people. The constitution gets its authority from the people of India. Moving on, republic. Republic implies that the head of the state is elected by the people and amongst all the people, it is not a hereditary ruler. It means that India will never have a king or a queen, rather it will always be a government which is elected by a people. Now further, the preamble explains four main objectives of a constitution: justice, liberty, equality and fraternity. Justice basically means economical justice, political justice and social justice. Social justice meaning that there is no discrimination of people based on their caste, race, religion, sex or gender. There is no, economical justice ensures that the wealth is distributed equally among the masses. Political justice grants the right to people that they have the right to participate into the political process of the country. Now liberty implies the liberty of thought, expression, belief, faith and worship. It means that freedom for the people to choose their way of life and their behavior in the society and the political views in the society. Liberty does not grant absolute freedom. It does not mean that a person can do anything they wish to do. They can do anything they want, but within the limits of the law. Equality. Equality means a person in India is treated equal before the law, irrespective of their race, caste, gender, religion, sex, etc. It guarantees equal opportunities for all. Equality means no section of the society is deprived from any sort of opportunities. Fraternity. Fraternity basically means feeling of brotherhood among the citizens. It ensures that we remain united as a nation. Now in the case of Keshwananda Bharati versus State of Kerala in 1973, the case questioned the extent of Parliament power to amend the constitution, specifically whether it could alter the fundamental rights under Article 368, which is the power of the Parliament to amend the constitution. Here the Supreme Court ruled that the preamble is not a part of constitution and it cannot be amended in any way that it alters the fundamental structure of our country. In the 1995, the case of Union Government versus LIC of India, the Supreme Court once again held that the preamble is an integral part of the constitution, but it is not directly enforceable in the court of justice. Now moving on, when I say that the constitution is a living document, what do I mean by that? How is the constitution a living document? The answer to it is that living means something which evolves over time as per to adapt to the new surroundings, much like other living organisms do. Similarly, the constitution is evolving and a living document. Our Indian constitution evolves from time to time and in order to improve it and benefit the society. Now question arises, how does the constitution evolve? The answer is simple, through amendments. The power of the amendment is under Article 368 of the constitution, which help us add new laws and bring about changes into the existing laws. Now one of the most well-known cases of Supreme Court, Navtej Singh Johar versus Union of India. The Supreme Court Supreme Court judgment on this case is on the decriminalization of Section 377 of the Indian Penal Code. The Section 377 of Indian Penal Code basically criminalizes unnatural sex between two genders. Now, as the society evolved with time, people started feeling that this section violated Article 14, that is the right to equality, Article 15, prohibition of discrimination, and Article 21, right of protection and personal liberty of the Indian Constitution. So on September 6th of 2018, the judiciary decriminalizes the section 377 of Indian Penal Code and allow gay sex among all consenting adults in private. In this judgment, the judiciary also interpreted the meaning of Article 14, Article 15 and Article 21, which is right to equality, right to prohibition of discrimination and right to protection respectively. Now there were several attempts previously as to decriminalize the section 377, but they were all dismissed by the court because the court felt that the society is not ready for change at this point. Now further into from 1970 to 1990, there was a significant change in the Indian society. The way the people think, the mindset, the lifestyle, the thought process, everything changed. The economical changes were brought in, the political changes were brought in, the social changes were brought in. And there was a significant change in Indian society, which is the main cause of maximum number of amendments during that period. Now, it is not at all like that the constitution is weak and we can amend it however we want. It is not at all like that. However, the constitution can be amended as per the needs of the society. The forefathers of the constitution have made sure that the constitution is not too rigid like that of USA or not too flexible of that like UK. But there are some things in the constitution that cannot be changed, and those are known as the basic structure of Indian constitution. The basic structure helps a constitution from being too flexible or being too rigid, and it curtails the power of amendment from the parliament. So the amendments are not something that shakes the structure of the constitution, but are an integral part of it. All of this procedure makes sure that the Indian constitution robust enough to avoid mistake evolution of the constitution. Now, to conclude, in my opinion, one of the most remarkable aspects of a constitution is its ability to evolve with time. The framers of a constitution, the forefathers of the constitution, have made sure that have gave us a solid foundation, but also made sure that there is a flexibility to adapt to change in the society. The basic structure of doctrine ensures that while fundamental rights are necessary, the core principle remains untouched. The Indian constitution is not just a legal text, it is also a reflection of our nation's value, the struggles of our martyrs and aspirations. It has guided us for decades and ensured democracy, justice, liberty, equality, fraternity, and remained at the core of our governance. Now, we being students of law and responsible citizens of this great nation, we must ensure that there is transparency in the governance, justice is accessible to all, and the rights of individuals are upheld. I would like to conclude with this, and thank you for your time and patience.
Arpita, thank you very much. It was really nice hearing the philosophy of constitution, and I think you have nicely defined what do you mean by a living constitution.
Yes, sir.
Because people speak on this topic, but nobody wants to touch this particular aspect. People speak, it is a living. Exactly it means what. So, thank you very much. A small token from Hammurabi to you.